Okay, we're finally going to start reading about Carlton Weiss's Trustee Handbook. Now, I did read 1 and 2. This is 3. I'm going to go ahead and share the screen. And we left off the last time on page 17. Let's see if I can expand this a little bit bigger. Yeah, there we go. I'm going to start over here. Even though I did read this paragraph already, I'll go ahead and start it here from express trust versus corporation. First, I must clarify, though I am referring primarily to corporations, included in the reference are all organizations which owe their existence to legislative acts, not limited to limited liability companies, limited partnerships, agencies, associations, etc. Though not classified as corporations, they avail themselves of benefits, privileges, and franchises of the state for their very creation and existence. Second, since we have already shown the distinct juridical personality of the trust as a legal entity, we will not re-examine it until we consider its personality. I did that the last time. Under the Roman civil law of the 14th Amendment in a later section. Did you hear that? Roman civil law of the 14th Amendment. That doesn't sound good, does it now? No. But it must be noted, the well-settled law, that the express trust is a lawful, legal, valid business organization with the right to hold property and sue in its business name. That's cool. And its uses in modern business have some of their strongest roots in England, Germany, and many of the United States, where it has been recognized for its superiority and even praised by such notable authorities as the Ohio Supreme Court for its effectiveness in the business of life insurance. The Declaration of Trust has been held to be an effective substitute for incorporation for its many advantages, which will undoubtedly shine though to the reader by the following table. Maybe it is shine through. They just made a little technical misspelling there. To the reader, shine through to the reader by the following table. I have prepared this table based upon the work by John H. Sears, who, after discussing the impact of the twin landmark cases on the grave lack of profitability of using corporations for inter alia dealing in real estate, went to task in outlining the distinct benefits of express trusts. The works by William C. Dunn, Guy A. Thompson, and Sidney R. Wrightington are cited as well, Mr. Sears says. Excuse me. The decision of the United States Supreme Court holding that the express trusts are not subject to the federal excise tax on corporations has emphasized this method of conducting business as compared with corporations. The best legal talent was soon impressed into the service of devising a means of affording the usual advantages belonging to a corporation without the authority of any legislative act, a method of placing the property into the hands of trustees who held the legal title and issued certificates similar to shares of stock to the Sustaki Trust, showing the interest owned by each possessed nearly all the advantages desired. That's great. This included the use of limited liability companies, joint stock associations, and co-partnerships, which are organized under enabling statutes, which merely enlarge the privileges possessed at common law. And they are therefore subject to state regulations, which may be equally burdensome to those imposed on corporations. Italics emphasized, supplied in original, bold emphasis and bracket information added. So here we go. Express trust governed under equity. Trust law is the most well-settled body of law in America. Trustees are sole authority except where delegated to agents or a board of directors. So it looks to me like there's a difference between a trustee and an agent or a board of directors. You know how you hear of some people that were on a board of directors, and then some people are the trustees. They are the sole authority. Excuse me, except where delegated to agents or a board of directors. Trustees afforded more leverage and powers are generally broader than corporate officers. Wow, that's great. Law provides that whatever any individual may lawfully do, the trust can do. Oh. The sky, nature, is the limit. Trustees' liability is limited by trust instrument and by signature on all contracts and instruments. Remember Boyd and Silverthorne, trustees not subject to subpoena. Wow, that's cool. Now let's go over here to corporation. Corporation is not like the express trust over there. So this corporation says governed under statute. Oh, whereas this over here, the express trust, is governed under equity. Equity is good. So the corporation, on the other hand, is governed under statute, forever changing according to political agendas and schemes, that's for sure. Board of directors are managers with limited defined powers to conduct business, hold regular meetings, etc. Whereas over here on the other one, the trustees are the sole authority, except where delegated to agents or board of directors. So back to this corporation, it says relatively broad powers, such as withholding companies. But corporation may not do whatever any individual may lawfully do. They can only do what is legal. The statute legislature is the limit. Corporate officers personally liable to legislature and to creditors for all ambiguous endorsements. Remember, Enron and Global Crossing cannot escape service of process. Oh, okay. So what do we have over here? Oh, let's read this part. Wait, stop. Did something just happen? Did I just change the page? I did. So here we are on 19. Lifespan. Oh, this is over here on Express Trust. The lifespan of 20 to 25 years at a time in order to avoid rules against perpetuities. Death of settlor or trustee has no effect on life or affairs of the trust. Oh, that's cool. Succession of power is quiet and private. Oh. Trust is not required to obtain business license. That's wonderful. That's really cool. Is that the same as doing business as business license? Find out. Trustees are not required to file reports with any entity. Oh, really? That's awesome. And are accountable only to the beneficiary, governed strictly under principles of equity. Ooh, I love that. Business name is naturally protected by injunction. Oh. May also use trade name or trademark for trust purposes without registration. That's great. All federal excise tax and state organization and franchise taxes are legally avoided. Really, that's fantastic. Let me read that part again. All federal excise tax and state organization and franchise taxes are legally avoided. That's wonderful. Not subject to foreign corporation laws of any state. That's really good. Not inherently subject to commercial regulation except for income derived from corporate stock and physical franchises under Article 1, subsection 8, Clause 1 and 3. Express trust is a valid legal entity in all states of the Union. That's really good. So trust may function, excuse me, as an Article 4, subsection 2, citizen of the United States via its trustee, not a 14th Amendment citizen. This citizen is understood in constitutional law as the private citizen. Let me read that part again, because that sounds really good. Trust may function as an Article 4, subsection 2, citizen of the United States via its trustee. Not a 14th Amendment citizen. This citizen is understood in constitutional law as the private citizen. Oh, so citizen of the United States, is that the private citizen? I guess so. Didn't know that. Oh, okay. So let's look at this corporation, what it says over here. Lifespan is perpetual or a certain number of years according legislative requirements. All officer changes must be reported, which records are open for public review. Yeah, that I know. The opposite is the case of the other side. Required to file statements and reports quarterly. Oh yeah, that sucks. Must apply for, this is corporation by the way, must apply for and secure fictitious firm name and must register all trade names and trademarks. Whereas on the express trust, it says business name is naturally protected by injunction. May also use trade name or trademark for trust purposes without registration. That's so awesome. So let's go back over to the corporation side. The opposite is the case, except for state taxes in certain states. In either respect, all corporations are taxed indirectly via inflation. Whereas over here on the express trust side, it says all federal excise tax and state organization and franchise taxes are legally avoided. I'd like to know how you do that. That's cool. So back over here on the corporation side, it says inherently subject to all foreign corporation laws and public policy regulation. Corporation is 14th Amendment citizen. Wow. Regardless of citizenship of corporate officer. Wow. So the corporation like Kmart, Walmart, Costco, Taco Bell, the corporation is a 14th Amendment citizen, huh? The slave, the one that pays the taxes. Interesting. Generally, state corporations require officers to be citizens as well. This citizen is inherently public due to the nature of the amendment. Whereas on the other side, the express trust, this citizen is understood in constitutional law as the private citizen. Cool. That's awesome. So look here at the very bottom, it says 14th Amendment citizens under the Roman civil law, private international law, admiralty, maritime law, are inherently public with only relative privacy. Hmm. So page 20, it still goes on. Over here on the left side, it says trustees have absolute rights and privileges to engage in commerce under protection of the federal Constitution. Whereas the corporation side says corporate officers have relative right and privileges to do so and incur more taxability by doing so. Over to the trustee side, it says trustees issue certificates in the manner prescribed by trust instrument. Certificate holders have no say in the administration of trust affairs. So what I noticed in the one that I have, the trust that I had made, let me grab it here. They came with certificates that, they kind of look like, awards type of thing, like this type of thing with a border. And yeah, these are the certificates right here. See them? And they even have like a common law trust organization. You put the name there and the deed of transfer. And it says pursuant to the contract dated whenever you created your trust, your irrevocable trust, that's the one I have, irrevocable trust organization, and in compliance with all the terms and conditions contained thereof. And you can put someone that you know, like your grandchild or your child, holds 10% of the actual all name capital trust. Trust certificate units subject to the following provisions, terms, and conditions. And then they have like 5 different, conditions. Like the holder shall be entitled to a proportionate share of all distributions declared, made by the trustee in order course of business or upon liquidation of the trust organization. So stuff like that on there. But you can have them all made for the beneficiaries of your trust. All right, so let's see, where are we? Okay, so over here. Now, in the corporate side, it says you must go public in order to issue stock. Oh, that's interesting. Stockholders have a relative say in affairs depending on the extent of their holdings, whereas on the left, it says trustees issue certificates in the manner prescribed by trust instrument. Certificate holders have no say in the administration of trust affairs. So like with my grandchildren and my daughters, they don't have any say of the administration of the trust affairs because they are the beneficiaries. They get like 10% each of them of the estate. So let's look here. Interest of the beneficiaries well protected by equity. Cool. Power to secure information as to the actions of the trustees in trust affairs is no doubt superior to the rights and remedies of stockholders in corporation. Let's go over to the right side where it's talking about corporations. It says stockholder rights protected by courts, yet the basic statutory nature of corporations allows for abuse. Stockholders are generally at the mercy of someone. Interesting. So over to the left, we're going to look at the express trust. Units of interest in the trust are not personal property or certificate holder and carry no liability as such. And then over here on the right, this is for corporations. Shares of stock are personal property in the hands of owner, and taxes issue on same property against both owner and corporation. So let me go back and read what it says in the express trust. Units of interest in the trust are not personal property or certificate holder and carry no liability as such. Also on the express trust side, it says no legal obligation to maintain the capital and refrain from paying dividends out of capital. Trust instrument governs. And over here on the right, it says the opposite is the case. So apparently there must be a legal obligation to maintain the capital, and they must pay dividends out of capital, and trust instrument does not govern. That must be the opposite of the corporate. So let's go over here back to the left side where it's the express trust side. May prosecute, defend litigation in trust or trustee name without compromising legality. Same rules as to parties and procedure at law and in equity are applicable. Now let's go over to the corporate side. May bring and defend litigation in the corporate name and entity only. The process of piercing corporate veil succeeds mostly due to confusion of personal and official capacities by officers. So let's go back over here on this side and see what's the difference again. May prosecute, defend litigation in trust or trustee name without compromising legality. Same rules as to parties and procedure at law and in equity are applicable. So while the mortality rate of corporations and the like have historically remained high, meaning that they don't die, they stay up there, express trusts remained, and indeed to this day continue to remain vital. Also, as the table shows, that table that we just read, many of the powers of an express trust are substantially the same as those of a corporation in effect, but without the legislative requirement of registration. That sounds good. In order for those powers to be activated, that's fantastic. These advantages and more have been and are still seized by some of the shrewdest, wealthiest individuals and families in America and from abroad. But the widely perceived yet untraceable wealth of such individuals and families like the Rothschilds, Rockefellers, Kennedys, Forbes, and many of the American founding fathers, plus countless modern day politicians, are strong circumstantial evidence of this. One may find many articles and information as well as quotes attesting to this. Lastly, it should be mentioned that unlike the corporation, there is no lawful method by which to pierce the trust without the express permission or implied consent of the trustee, or some unlawful activity on the part of the trust giving rise to a bona fide cause of action. As a result, virtually no direct evidence of the trust's existence can be found unless it is made to be found via recording. Even then, it can only be heard by a court of competent jurisdiction, which, as you shall see in the sections ahead, is very hard to find nowadays. This is protection at its finest, hiding in plain sight. For as the maxim goes, benevixi que benelatuit. I don't know what that means. 124. He lives well who conceals himself, his assets well. Benevixit qui benelatuit. Can you say that? He lives well who conceals himself and his assets well. Oh, cool. Here, there's a quote here. One such quote is that of John D. Rockefeller, who is reported to have said that the key to true wealth and power is to own nothing and control everything. That's true. Your author is confident that the reader will see the self-evidence of this truth, and the express trust throughout the relatively short history of America has served to facilitate this practice. A search for the assets of the Rockefeller family will prove the truth of this philosophy. The words trade and commerce are often used interchangeably, but strictly speaking, commerce relates to intercourse or dealings with foreign nations, states, or political communities, while trade denotes business intercourse or mutual traffic within the limits of a state or nation, or the buying, selling, and exchanging of articles between members of the same community. Black's Law Dictionary, page 336, 4th edition, Rev. 1968. I don't know what Rev means. Review. HJ Resolution 192 was tacitly repealed on October 27, 1977, as codified at 31 USC subsection 5118A1 and D2. And though gold clauses have since been upheld as legally enforceable again, Faycorp versus Frederick and Nelson, Seattle Incorporated, 896 F2D 1227, CA 9 Washington, 1990. It successfully put in place a system which survived the repeal. And thus today, most participants make no noticeable use of the now legally enforceable gold clause. Therefore, all discussion relating to HJR Resolution 192 remains valid in the sense that nothing has changed materially since its repeal 30 years ago. Let's see, we were on, that's what I thought, okay. So page 22, under this jurisdiction, the federal government, Congress, has full and direct contact with the trust as they see fit for the benefit of public policy regulations. Let me go back. Hang on, 22. Oh. Okay. I skipped this part. I'm glad I stopped. Okay, so understanding commerce. Here is where we begin to address the express trust in action. As shown above, the trust may engage in all manner of trade and commerce, but before taking the step of doing so, the reader would greatly benefit the trust by understanding the nature of commerce in 21st century America. And for my brief explanation of the subtle intricacies involved, I will rely upon the two works by Lee Brobst et al. I will not go into a detailed explanation of the Constitution or the history of commerce for want of space, but I would suggest that the reader read the works relied upon herein. When the trustee is engaging in trade or commerce in behalf of the trust, acting under general common law, the trust is within the jurisdiction over which the literal and absolute protections of the Bill of Rights extend, and he has no direct contact with the federal government. Under right of contract law, protected by the federal Constitution, the trustee may enter into the 14th Amendment jurisdiction via contract. Example, by willfully availing the trust of benefits, like the quasi-corporate privilege franchise of limited liability for the discharge of debts using Federal Reserve notes, pursuant to the economic system established under former HJR Resolution 192. Contrast discharge with the payment of debts, with standard gold-backed currency under the original Coinage Act of 1792. Under this jurisdiction, the federal government, Congress, you know where Congress is located at? Washington, D.C. And Washington, D.C. is the federal government, has full and direct contact with the trust as they see fit for the benefit of public policy regulations known as codes and statutes of this jurisdiction. Let's read that again. Under this jurisdiction, and I think it was from the 14th Amendment, citizen, back there, look, oh, let's go back. See, it's talking about down here. The trustee may enter into the 14th Amendment jurisdiction via contract. And it says under that jurisdiction, the federal government, Congress, under the 14th Amendment one, has full and direct contact with the trust as they see fit for the benefit of public policy regulations known as codes and statutes of this jurisdiction. Okay, so this makes the federal government a third-party intervener in the affairs of the trust by operation of law, because the trust, as with the 14th Amendment citizen, is being allowed to get away with not truly fulfilling its commercial contracts as it's required under the common law of contracts. I will show you how this can all be avoided in later section. Good, because I didn't understand that. The resulting nexus or confederacy developed under HJ Resolution 192 is an affiliation known better as an association. And the common enterprise of this unincorporated society is to offer all Americans a so-called privilege in the form of what is better known as a quasi-contract to participate in commerce without payment of debts for social security purposes. Moreover, this unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1, Section 10, but is allowed, upheld, and protected by Article 1, Section 10 that upholds the obligation of contracts. This amounts to a federated, unincorporated society by operation of law, which is contractually protected by the Constitution. In the same way, the express trust and its trustees are. The trust and or trustee reserves the right to domicile themselves in the union under Article 4, Section 3, Clause 1, and thus to contract under Article 1, Section 10, despite the fact that they cannot pay their debts. Oh, that's so cool. In other words, Congress cannot compel the trust or its trustees to participate in a federal, interstate, unincorporated banking association under Article 4, Section 3. You should look that one up, you guys. Clause 2 and HJ Resolution 192 for the non-payment of debts. The choice of law is up to each person still. Well, let's go down to what this says down here. The federal government's power of regulation in this manner is fully constitutional, deriving its authority from Article 1, subsection 8, Clause 1 and 8, being one of the general legislative powers. The relationship between Congress and the 14th Amendment citizen is controlled under Article 4, subsection 3, Clause 2, because there is no physical federal or state charter issued to regulate the relationship. Here's another. Brobst et al. Supra at page 7 to 8. An association is defined as an unincorporated society, a body of persons united and acting together without a charter. But upon the methods and forms used by incorporated bodies for the prosecution of some common enterprise. Black's Law Dictionary, page 156, 4th edition, review, 1968. Huh. All right, so we got to the bottom of 22, and we will continue on. I'm getting tired. That's just how it goes. I can only read so much. Have a good night.